Good evening, my friends. I'm Caroline Fredrickson. I'm the president of the American Constitution Society for Law and Policy. And it is my very great pleasure to welcome you all to the 2013 National Convention and Justice for All. I want to thank all of you for everything you have done to build ACS. And I would just say, you might want to look around, and despite the tornadoes and the hail and the thunderstorms and the massive flight cancellations, can you look around the room we have here? This is where we are in 2013 for ACS. And everything that we have become is because of what all of you have done to get us here. So thank you. As you all know, this convention brings together the best and the brightest in the legal community. And I'd like to think that ACS and all of you are the heart of one of the fastest growing and most influential progressive legal organizations. So I want to make sure that we all have a chance to talk and share thoughts. So we do, of course, have a Twitter hashtag. Happy to see your comments. It's at ACS 2013. So I want to take a minute to do a few little important business to thank those people and organizations that were so instrumental to putting this convention together. So first, I'd like to thank the host committee chairs, Dan Berger, Faith Gay, Bob King, and Anthony Romero. And our entire host committee. And our honorary host committee chairs, Representative John Conyers, Senator Patrick Leahy, House Democratic Leader Nancy Pelosi, and Senate Majority Leader Harry Reid. And the rest of the honorary host committee. But I also want to thank a very important group of people for me who really have made ACS as strong and vibrant as it is, and that is the members of the ACS Board of Directors, who are an ever wonderful source of leadership and inspiration for all of us and the staff and for the organization as a whole. And I do also want to thank my very dear, committed, smart, and hardworking colleagues, the ACS staff. They do deserve a hand. But it would be a terrible thing to forget to say thank you to the people who are really making this happen at this moment. And that's the staff here at the Capitol Hilton, our host hotel for the third straight year. And I'd specifically like to thank Local 25, Local 99, and Local 51 for the hard work they're doing. Thank you. And of course, another group of people and organizations that really made this, this day possible are our critical underwriters: Google, Grant and Eisenhower, Kirkland and Ellis, Microsoft, the Service Employees International Union, Sussman Godfrey, the United Auto Workers, and Wilmer Hale. And our partners, Epic Systems, Facebook, GCG, Faith Gay and Francesca Zambello, Leif Cabraser, Hyman and Bernstein's, Mayor Brown, Paul Weiss, Rifkin, Wharton and Garrison, Rust Consulting and Kinsella Media. Give them a hand. And our benefactors, Berger and Montag, Bernstein, Lidowitz, Berger and Grossman, Gilardi, Huntington Bank, Jenner and Block, KCC, Kessler, Topaz, Meltzer and Check, Labaton, Shusharo, Latham and Watkins, Seeger Weiss, Sidley Austin Foundation and the partners of Sidley Austin, Skadden Arp, Slate, Meager and Flom, and Verizon. So let's give them all a great round of applause. And now, I have a very great pleasure, and I think you will all very much appreciate hearing from our next speaker, because I get to introduce a longtime supporter and leader within ACS and the progressive legal community, and a recent and wonderful addition to the ACS board. Judge Nancy Gertner was appointed to the federal bench, and that was a good thing. Judge Nancy Gertner was appointed to the federal bench by President Clinton at the urging of Senator Ted Kennedy in 1994. She served on the U.S. District Court for the District of Massachusetts until retiring in September 2011. After leaving the bench, Judge Gertner became part of the faculty of Harvard Law School. She has written and spoken widely on various legal issues and has appeared as a keynote speaker, panelist, or lecturer on civil rights, civil liberties, employment, criminal justice, and procedural issues around the world. Few public officials over the years have participated more effectively, more forcefully in the public debate than Judge Gertner. In 2008, she received the Thurgood Marshall Award from the American Bar Association. At that point, she was only the second woman after Justice Ginsburg to receive it. She has long been and remains a leader and inspiration to progressives everywhere. And she has never been apologetic about her work or her commitment to justice. Her autobiography is titled, and I recommend it to you, it is a wonderful read, but it's titled, In Defense of Women, Memoirs of an Unrepentant Advocate. So I am pleased to welcome this unrepentant advocate to the board of ACS and to the stage tonight to introduce one of our keynote speakers tonight. So please join me in welcoming Judge Nancy Gertner.
Somehow I feel I should begin. Neither rain nor storm nor whatever will stop us. So I have a unique role here. My generation, and perhaps others as well, fell in love with our politicians. We fell in love with JFK. We fell in love with McGovern. We fell in love in Massachusetts with Ted Kennedy. And there are politicians you fall in love with, not because they're attractive, although they may be attractive, not because of their pedigree, the families they come from, not because, as in my state, they happen to drive a truck. It's an inside joke. Some politicians you fall in love with because of what they stand for, because of what they wanted to do with the power we are going to give them, because they are substantive, because they are the real deal. Elizabeth Warren is a senator to fall in love with. She's an academic, was an academic, and although the debate in Massachusetts didn't make this clear, she chose her research because of where her passions were. She didn't choose her research to be, archaeology and the law, for example, or the law of interstellar space. She chose to write about what mattered. She wrote about bankruptcy law. She wrote about credit crunch. She wrote about the things that she had seen, and she made a contribution. She became one of the nation's top experts on bankruptcy and the financial pressures facing the middle class. She was widely credited for the original thinking, political courage, and the persistence that led to the creation of the Consumer Financial Protection Bureau. The president asked her to set up the new agency to hold Wall Street and other financial institutions accountable, to protect consumers from the tricks that we had seen they were prey to. Time magazine called her the new sheriff of Wall Street for her oversight efforts. The magazine named her as one of the 100 most influential people in the world. Now, I knew Senator Warren as a speaker, and then I think we overlapped for about a minute and a half at Harvard. But I was particularly proud when she asked me to serve on the advisory committee for judicial nominees. It's hard to imagine an issue of greater importance to ACS and to the nation. In fact, I think I asked her, after she asked me, I asked her, "Are you sure you want me?" Sort of sends a little bit of a message. She handpicked the committee. She spoke to everyone on it. She was engaged. This was not an abstraction. This wasn't about picking someone who had simply gone through the system and their time was due. This obviously wasn't about patronage. This was about quality. And she told each of us that we were going to look for judges not in the usual areas. We were going to look for diversity, not just ethnic and gender. We were going to look for diversity of background, diversity of legal experience, diversity of economic background as well. We were going to look for substance. In fact, my conversations with her reminded me a little about the comment that Justice O'Connor made after Thurgood Marshall died. She said that when he was in the room, he changed the conversation, not just because of his intellect, which was substantial, but because he had been the only one in the room who had experienced the segregated South, and that made a difference. I'm also reminded of what Ruth Bader Ginsburg had said. When she goes on the bench, she's the only one who had been discriminated against and who had represented people who had also been discriminated against, and they make a difference in the conversation. So what she said to me and what she said to each of us triggered an amazing selection process, an amazing conversation, and I predict some rather amazing selections. We should be in for a treat tonight. Senator Warren's speech before the 2012 Democratic Convention was hailed as one of the convention's most popular and effective. And somehow I doubt if that will be her last major convention address. Please join me in welcoming a senator to fall in love with, Elizabeth Warren.
Thank you so much. Thank you. Sit down, sit down. Thank you. Thank you, Nancy, for the very kind introduction. And Nancy and I will be the only two people in this room who will believe this once you hear the rest of the speech. Nancy and I did not coordinate. So just keep that in mind as we go forward through this. But what it does say is I really do want a chance to thank Nancy publicly, not only for her years in public service on the bench, but for the enormous energy she has put into service after her time on the bench, including heading up a judicial selection committee for us in Massachusetts. So thank you, Nancy, for all you do. Thank you, dear. I also want to say thank you very much to Caroline, to Peter, to everybody here at ACS for all of the hard work you do. You know, when I was at Harvard, I was always happy to attend any ACS event. I was happy to contribute to the ACS Journal. I even managed to steal a few ACS students to get them to come be research assistants. So it's been terrific to have a front row seat, or well, at least a second row seat, as I've watched ACS grow from the kernel of an idea into a real force. It has been wonderful to see. ACS is a force that is more essential today than it has ever been. On hotly debated issues about law, about policy, conservatives are organizing themselves to put serious pressure on Congress and the courts to strip away important rights and reforms that we have fought fiercely to win. We need ACS to push back. That's what this is about. John Adams and the founders, all of the founders, were very worried about the concentration of power. And John Adams, who I now regularly quote since he's a Massachusetts native, wrote our state constitution, expressed the idea well. He said, power must be opposed to power, force to force, strength to strength, interest to interest, as well as reason to reason, eloquence to eloquence, passion to passion. Balance, said Adams, is critical. Here in Washington, power is not balanced. Indeed, power is becoming more concentrated on one side. There are powerful, deep-pocketed corporate interests lined up to fight to protect their privilege and to resist any change that would limit corporate excesses. I saw one of the example of this, a regular example, up close and personal, following the 2008 financial crisis, when I fought for stronger financial regulation against big banks. But there are many, many more examples. These big corporate interests are savvy. They fight every day on Capitol Hill and in the agencies, devoting enormous resources to the task of bending legislation to benefit themselves. But they also devote enormous resources toward influencing the courts. Why? Because they know that influencing those who interpret the law is another extremely effective way to achieve their goals. Now, in our democracy, when we write laws, reasoned debate, public opinion, political accountability are all factors that at least have a chance to thwart the powerful interests. But even if those powerful corporations lose the fight in Congress, and remember, sometimes they do lose the fight in Congress. We've got an NLRB, an EPA, and now we've got a new Consumer Financial Protection Bureau. Sometimes we get this done. But even in those cases, they can turn their defeat into their victory if they can get a favorable court opinion. Powerful corporate interests understand that if they can rig the courts, a friendly judicial system will give them a second bite at whatever they want. So I came here today because I had a message I wanted to bring personally. And here it is. There is an intense fight going on right now over what our federal courts will look like. It is a fight over whether those courts will remain a neutral forum, faithfully interpreting the law and dispensing impartial justice, or whether we will see corporate capture of the federal courts, with the courts transformed into one more version of the rigged game. And right now, we're losing that fight. The reasons are many. Consider the composition of the federal bench. Look at the federal bench, and you'll see a striking lack of professional diversity among the lawyers who serve as federal judges. According to a study published by ACS earlier this year, as of 2008, the federal bench was dominated, this is a quote, dominated by judges whose previous professional experience is generally corporate or prosecutorial. The study examined biographies of 162 judges listed in the Almanac of the Federal Judiciary. It found that 85% of the judges had worked in private practice, and also noticed that it was, and again quoting, clear from the judges' biographies that a sizable number of them work for large, well-known firms that tend to represent corporations. Meanwhile, only 3%, that's 5 judges out of a total 162, had substantial legal experience working for nonprofit organizations. And none of those 5 had worked for such an organization since 1981. Similarly, only 3% of the judges had worked for organizations or government agencies that enforce civil rights. Only 3 judges in total appeared to have worked for organizations representing low-income Americans. And only 1 judge, 1 out of 162, appeared to have substantial experience litigating consumer protection cases. Now, since taking office, President Obama has been responsible for some notable exceptions to this trend. District Court Judge Edward Chin worked for many years as a staff attorney for the ACLU, and the president stood behind the Chin nomination. He renominated him 3 times over 3 years before the Senate finally agreed to confirm him. Generally, however, even the president's appointments have been in line with prior statistics. A study by the Alliance for Justice shows that the president has nominated 41 private sector lawyers to the federal appeals court while selecting only 3 legal aid lawyers and 3 public defenders. Now, I want to be clear. There are some really, really talented judges who come from the private sector. I myself have worked for private clients. And it is, of course, true that the personal views of an attorney often diverge from those of his or her clients. But I think diversity of experience really matters. At his induction ceremony, Judge Chin was quoted as saying he never considered withdrawing his name from consideration. And here was his reason. He said, "I believe that someone should not be disqualified from the bench simply because they once represented the voiceless and the unpopular, rather than the wealthy and the powerful." And I believe Judge Chin is right. That's right. So it's the composition, but another important reason why we are at serious risk of losing this fight is the increasingly brazen and ideological pro-corporate tilt of most of our federal courts, and especially the Supreme Court and the D.C. Circuit. Data on the Supreme Court in recent years shows a heavy pro-corporate tilt. The 5 conservative justices currently sitting on the Supreme Court, are you ready for this, are in the 10 most pro-business justices in half a century. And Justices Alito and Thomas are number 1 and number 2 in half a century in being pro-corporate. Or take a look at the win rate of the Chamber of Commerce. According to the Constitutional Accountability Center, the Chamber moved from a 43% win rate during the very conservative Burger Court to a 56% win rate under the very conservative Rehnquist Court, and now they are at a 70% win rate under the Roberts Court. Follow this pro-business trend to its logical conclusion, and sooner or later, you will end up with a Supreme Court that functions as a wholly owned subsidiary of the Chamber of Commerce. The consequences of this pro-corporate shift are staggering, and it's not just the Affordable Care Act, which came within an inch of being invalidated by the Supreme Court, or Citizens United, which unleashed an avalanche of secret corporate money into our political system. Those cases get a lot of attention, but other cases are just as damaging. We have a Supreme Court that chose the absurd legal formalism over equal pay for equal work, forcing Congress to step in and correct their obvious error in the Lilly Ledbetter case. We have a Supreme Court that rewrote our established understanding of the standards for filing lawsuits in Iqbal and the Twombly cases, making it easier for sophisticated deep party pockets to prevail against underdogs. And we have a court that looks for every opportunity to undermine class actions, even if that means corporations can roll over millions of people. This isn't right. In addition, the Supreme Court's unique ability to pick and choose which cases it will hear gives it tremendous power to shape the evolution of the law. According to data collected and analyzed by Adam Chandler at SCOTUS blog, The most successful groups at getting the Supreme Court to take their petitions are, and I'm quoting, pro-business, anti-regulatory, and ideologically conservative. In the top 15 are some of the biggest advocates for big business. The Chamber of Commerce, number one again. The Cato Institute, the National Federation of Independent Businesses, the Pharmaceutical Industry Lobby, and the American Bankers Association. These interest groups see a Supreme Court that scholars and analysts alike have called the most pro-business court in modern history. They are kids in a candy store, kids with plenty of money to spend, bringing case after case to advance their political agenda. Then look beyond the Supreme Court to the D.C. Circuit, which hears most of the appeals of decisions. It has been called the second most important federal court in the land, and the story here is no better. Some of the most consequential decisions of our time, the decisions about whether or not Wall Street reform will have real bite or whether it's going to be toothless, are only now bubbling up through the D.C. Circuit. Swaps dealers in the security industry are trying to gut the Commodity Futures Trading Commission, rules that prevent excessive speculation on Wall Street. The Business Roundtable and the Chamber of Commerce are fighting to prevent shareholders from getting information about candidates for boards of directors. The list goes on. Auto dealers, oil companies, others are challenging the rules left and right. And the next time you hear someone claim that the D.C. Circuit doesn't need any more judges, has 3 vacancies right now, you can remind them that the president with the most appointees sitting on the D.C. Circuit right now is Ronald Reagan. It's been 25 years since his last appointment. Now, as lawyers and law students, we know that the D.C. Circuit must defer to agency interpretations. That's the law. It's not allowed to substitute its own judgment for that of the agencies. But that's no longer the expectation in Washington. The D.C. Circuit seems increasingly hostile toward agency rulemaking by financial regulators. And the result is that some agencies in Washington, minority commissioners are getting extra leverage in policymaking because it is increasingly believed that if the minority dissents, the D.C. Circuit will use that dissent as a way to swoop down and nullify the rule. We've already seen this happen. In a case called Business Roundtable versus the SEC, the D.C. Circuit struck down a rule developed under Dodd-Frank that would give shareholders more information in nominating directors for their companies. In that case, the court held the rule was arbitrary and capricious and even cited directly to the dissenting statements of the losing commissioners. So let's put these pieces together from beginning to end. Because of Citizens United, powerful interests have undue influence over elections and therefore get legislation passed. The Affordable Care Act dramatically rewrites Congress's authority to regulate under the Commerce Clause. The D.C. Circuit's aggressive approach to reviewing agency decisions means that some laws passed by Congress, in effect, will be neutered by a hostile court. And then even if the laws get passed and the agencies make the regulations stick, decisions to restrict access to justice means that individual citizens may never be able to get in the door to exercise their rights in court. Each one of these decisions is a serious problem, but together, each magnifies the impact of the other. So, what do we do? Well, I don't kid myself. Fighting back is not easy. Powerful interests invested in the status quo, they know what's at stake. They are organized, they are effective, and they come to this battle armed with lobbyists and lawyers. We are up against a conservative movement that for 30 years, since President Reagan, has dedicated itself to packing the courts with pro-business, anti-regulation conservative allies. They are tough and they are prepared. We will not win all of the fights ahead, but if we are going to have a chance, We begin by speaking out about what is happening in our courts. We have to do that. We have to be willing to speak out, and we must make judicial nominations a priority, a priority. It is time for a new generation of judges, judges whose life experiences extend beyond big firms, federal prosecution, and white-collar defense. We need sustained pressure on those judges to get them in front of the United States Senate. We need pressure on our president, pressure on our senators, pressure on the press. And if the judges don't get a vote, if they are blocked, if they can't get through, then we need to change the filibuster rules to get them through. You bet. That's true. So we got a lot of different folks in here who have a lot of different interests, but I want to make this as clear as I can. If you care about the Affordable Care Act, if you care about the Voting Rights Act, if you care about financial reform, then your fight is not just a fight about policy. Your fight is not just a fight in Congress. Your fight is in the courts. Your fate is tied to judges who will decide these cases, and your fight must be to bring a new generation of judges to the bench. That's what we have to do. Yes, we do. We don't need judges who put a thumb on the scales of justice. We need judges who will be fair, judges who will be even-handed, and judges who will have the experience to consider all sides to an issue. That's what we need. So, this is it. I love coming here. I love being with ACS, but I got to say this. I always come here to ask you to fight. This is going to be a hard fight. There will be many battles ahead, but I truly believe in what we can do together. There are people in this room and lawyers all across the country who are active in ACS, and they are tough, resourceful, and creative. Together, we can get a new generation of judges on the bench, and we can prevent the corporate capture of the federal courts. Thank you for having me here tonight. Let's go fight. You bet. Thank you. Thank you. Thank you.
Wow. What an inspiring speech. Good evening, everyone. My name is Aparna Gupta, and I'm one of the assistant directors of student chapters here at ACS.
And I'm Zach Game. I'm the other assistant director for student chapters.
This has been a really exciting year for our student chapters. We have so many students in the room tonight, and we would like to take this moment to recognize our strongest chapters and individuals. This year, we've grown to nearly 200 chapters across the country, and we held our first ever ACS Law Student Convention at Stanford Law School.
The first student chapter award is for the Constance Baker Motley Student Writing Competition. Every year, ACS, in conjunction with the University of Pennsylvania ACS chapter, awards the prize and an offer of publication to the strongest paper furthering and promoting a progressive vision of the Constitution and public policy.
So this year's runners-up are Leilani Fisher from BYU Law School and Correll Murray of Stanford Law School. And the winner for this year is Jeremy Amar Dolan of Cornell Law School. So congratulations to all the writers.
Our first chapter award is the Rising Chapter of the Year. This award goes to the new or recently revived chapter that has done the most to advance progressive legal causes. This year's winner is Rutgers School of Law, Newark.
We are so proud to partner with the Center for Reproductive Rights to present the Reproductive Rights and Justice Award. This award is given to the chapter that has the greatest impact on the area of reproductive rights. And this year's winner is Indiana University Maurer School of Law.
We would also like to recognize our chapters who have held more than 20 events this past academic year, focusing on our national priorities with the Programming Award. This year's winners are Drexel, Faulkner, Florida International, George Mason, Georgia, Harvard, Indiana, Loyola Los Angeles, Michigan, Missouri, North Carolina, Ohio State, Penn State, Richmond, SMU, St. Louis University, Stanford, Texas, the University of Chicago, William and Mary, and Yale Law School.
And our final award for the night is for Student Chapter of the Year. This award goes to the chapter that has shown the greatest strength in meeting ACS's mission and goals. This year's winner not only held a large number of high-quality progressive events, but also displayed a really keen creativity by creating a unique publicity campaign that substantially increased its membership on campus. The winning chapter also developed programs that facilitated strong connections between student members and local lawyers in the lawyer chapter. So led by faculty advisors Lynn Blaze and William Forbath, and chapter president Meredith Kincaid, our student chapter for 2013 is the University of Texas at Austin. So congratulations to Longhorns and all of this year's winners. Please enjoy your dinner.
I'm Judy Scott. I'm a member of the board of directors of ACS. Thank you. Also general counsel of the Service Employees International Union and partner in James and Hoffman. So I want to thank you it's been a great evening, and I have the privilege of introducing the evening's closing speaker, Oregon Senator Jeff Merkley. Senator Merkley has spent his lifetime in public service. His entire career has been motivated by a simple philosophy, that each of us has a responsibility to make the community, the nation, and the planet a better place. He is certainly the epitome of the convention theme, and certainly has one of those diversity backgrounds that was described by Senator Warren. Senator Merkley led Portland's Habitat for Humanity and worked with low-income families to rebuild neighborhoods, helping scores of Oregonians purchase their first home. Elected to the state legislature in 1998, within 8 years, he was Speaker of the House. His session was described by the Oregonian, the state's largest newspaper, as Oregon's most productive in a generation. We could use a little bit of that here in the Senate, as we've heard. In 2008, Senator Merkley became the first Oregonian to defeat an incumbent U.S. Senator in over 40 years. In just his first term, he has already been a strong voice for healthcare reform, pushing to expand access to affordable insurance to small businesses and working families. He has emerged as a leading proponent of capturing the clean energy revolution to strengthen the American economy. And he has forcefully argued for strategies to help families at risk of losing their homes and to correct the abuses by Wall Street that led to the financial crisis. Senator Merkley was also honored to take the baton from late Senator Ted Kennedy as the lead sponsor of the Employment Non-Discrimination Act. And he has made full equal rights for gay, lesbian, bisexual, and transgender Americans a signature priority. In addition, in an area close to the hearts of so many of us here at ACS, Senator Merkley has led the charge to reform Senate rules to fix the filibuster, prevent gridlock, and fight against blocking the votes on the nominations of highly competent judges and presidential appointees, including the 5 nominees to the National Labor Relations Board, our federal labor law agency that now is at risk at shutting down in August. Just last week, Senator Merkley held his first hearing as the new chair of the subcommittee on economic policy of the Senate Banking Committee, where a panel of working people and economic experts provided much needed perspective on the state of the economy and the future of the middle class. But Senator Jeff Merkley doesn't just talk the talk, he walks the walk literally. Several years ago, this is something we at SEIU know well, in Oregon, we were, the union, doing home visits to child care workers who were organizing into our union. Jeff Merkley joined union members and staff for a morning orientation and then spent the entire day going door to door with SEIU organizers. Now, there aren't a lot of U.S. senators with such strong commitment to working families and their unions. So needless to say, it is with extreme great pleasure that I introduce to you a great American and a fighter for working families and, frankly, another senator you can fall in love with, Senator Jeff Merkley.
Thank you all. Thank you. Well, thank you all so much for inviting me to come join you. I am the non-lawyer here among 1,000 experts. And so basically my job is to tell you all that as you work in your various walks of life, it's up to you to change the world. You all in this room can wreak enormous differences on the experience of our nation for our working Americans, and that is work well worth doing. Didn't Elizabeth Warren do a tremendous job? It's just, I feel like wearing one of those little wristbands, WWEWD. What would Elizabeth Warren do? She is a terrific addition to our caucus, and I know folks across America pitched in to help in the race, because essentially, with 100 senators in the U.S. Senate, every one of them are your senators, and every battle matters. And I am so pleased to have her advocacy for and understanding the challenges that are being faced by our middle class, a middle class that's being squeezed by powerful forces, by the cost of going to college, by the collapse of home ownership, with the values dropping enormously, with the loss of living wage jobs. These are all huge factors, and she is going to be an enormous, enormous force. Now, I wanted to thank Judy so much for introducing me. Throughout her career, she has been an advocate for working people in virtually every area of labor law, from mine workers to women's rights to so on and so forth. And so, Judy, thank you for the work you do, and thank you for the introduction. Now, Judy mentioned Employment Non-Discrimination Act. And I just wanted to tell you that when I was working to recapture the House for the Democrats in Oregon, and this is something in 2003, I decided to drop my paid job, if my wife would allow me, and basically take on the job of trying to take back the Oregon House, because we had a Democratic Senate, a Democratic governor, and we had a House that blocked everything. So our governor, Governor Kitzhaber, who is now governor again, was known as Dr. No. But now, with a Democratic House and a Democratic Senate, he's known as Dr. Yes. This is a good change. Well, one of the battles when I became speaker, there were two things that I had said to the LGBT community, that we would fight for full domestic partnerships. We have a constitutional ban on marriage, and we would fight for full basic rights. And it was a great joy in 2007 to win both those battles and take a huge stride forward for our LGBT community. I didn't have a lot of interactions with Senator Kennedy. I talked to him about serving on his committee. I talked to him about sailing. I talked to him about health care, but he wasn't with us very long, and we didn't know each other extremely well. So when he and his team asked me and my team to take on the leadership, to carry the torch on employment non-discrimination, I was deeply, deeply honored. And I want to tell you that tonight, minutes ago, Majority Leader Harry Reid became the 50th co-sponsor of Employment Non-Discrimination Act. "17 years ago, we had a vote on employment non-discrimination. It was 49-50. We lost by one vote. One senator was absent tending to his ill son. Had he been there, we would have had 50-50, and the vice president would have voted yes, and we would have won it 17 years ago. It is about time that anywhere you go in this country, you can walk and know that you can walk in any job, and you can't be thrown out of the job or banned from getting the job in the first place because of your sexual orientation. Now, we need guardians of the law, and I know that you all are, because we have fundamental threats to our Constitution. We have fundamental threats to our democracy. Your dedication as an organization to protect and enhance the fundamental principles of human dignity, individual rights and liberties, genuine equality, and access to justice are needed now more than ever, and so I am so delighted that you all exist. So I thought I would bend your ears a little bit about a few of the big challenges we have, and this might sound a little bit like I'm echoing Elizabeth Warren, and I'm proud to do it. Let's talk about secret money. Let's talk about secret law, and let's talk about a broken U.S. Senate and how to fix it. Starting with Citizens United, a 5-4 decision by the Supreme Court that allows unlimited corporate spending on campaigns. Now, think about a board of a company, a very large company. They can spend a few percent of their net profits and basically spend as much as the rest of America put together. This is no exaggeration. Take Exxon. If in the last election they had spent about 4% of their net profits, and in 2008 it would have been 3% of their net profits, they would have spent as much as the rest of America on the presidential campaign. That's the type of power concentrated into a single boardroom with a group of folks not spending their own money, but spending the shareholders' money, and being allowed to do it without even disclosing to the shareholders that they're taking that action. That is a humongous force, and it's a flow of money, a flood of money, a tsunami of money that threatens to drown out the voice of America. And that is not okay, and we have to change it. I think of how President Lincoln said, and he summarized the experience of the U.S. as saying it's government of, by, and for the people. And of course, our Constitution starts out, we the people. And as students of the Constitution, you've probably looked at it so many times and seen that the writers of the Constitution put those first three words in supersized print to remind us what this is all about. But Citizens United is government of, by, and for the powerful. It's a very different vision of our nation. So we tried to stop it in 2010 with the Disclose Act, at least to be able to say that all Americans should know who is spending money. When a tobacco company comes in and puts $1 million in my campaign because I fought to end their new strategy for addicting kids through a product that's a form of, it's tobacco candy, when I want the citizens of Oregon to know that's a tobacco company that's doing that. And then I can tell them why. And then the citizens can decide whether they liked the fact that I tried to stop that product or not, and so on and so forth through other powerful organizations. We did not get cloture by one vote twice in 2010. 59, 61, 59, 31, 41, thank you, 59, 31. It may be that 30 years from now, we look at that missing vote twice, and the fact that we were forced to get cloture and get that 60-vote standard as a moment when our country took an enormous turn, a turn that it shouldn't take in our constitutional vision. Now, so re-pursuing the Disclose Act is one approach. A constitutional amendment is another, and there are terrific ideas put forward by Tom Udall of New Mexico and Bernie Sanders. I'm sponsoring both of them, co-sponsoring both of them. Their path is very difficult to get the supermajority needed for constitutional approach. But how about corporate disclosure? How about the principle that the owners of companies should actually get to know how the company is spending money on campaigns? That's something that's much more within reach, and we need to make it happen. Let's switch to another piece of this puzzle, the 501c4. Now, the 501c4 loophole comes from a dramatic difference between the plain language of the law and the regulation. The plain language of the law says that donations to an organization must be used exclusively for social welfare activities. Now, I thought exclusively was a fairly clear standard. Sounds like 100% standard. The IRS put in a regulation, and it says, and I went to the floor of the Senate and read the law and then read the regulation because I couldn't really believe that this was true. The regulation says the word exclusively means primarily. That's 100% standard being reduced to a 51% standard. Now you have a social welfare organization that in which the donors are shielded because it's social welfare, charitable activities. Now the donors are shielded, and you can spend the bulk, half the money on political activities. And if the IRS isn't watching, you can spend a lot more than half the money. And the IRS has not been watching. So that's where we are. Now, the IRS made a terrible, terrible mistake. No question, it's a scandal and unacceptable that there be any sort of ideological screen put forward in qualifying 501c4s. But it is also unacceptable to have this huge loophole, this Karl Rove Crossroads loophole. Now, Karl Rove and Crossroads aren't the only ones using this. There are groups on the left and there are groups on the right. They just happen to be one that really promoted it and said, we can shield your donations and use this structure. Well, how about we ask the president to cast a major act in favor of transparency and close this 501c4 loophole? From secret money to secret law, kind of a hot topic right now. Yesterday, General Alexander, the director of the National Security Agency, was testifying in front of the Senate Appropriations Committee. I was assigned to that committee this year, and so when it became my turn, I pulled out my cell phone, I held it up, and I said, General, what were the legal grounds for the NSA to acquire my cell phone data? And that's a pretty simple question. But it takes us to the heart of the dilemma that we face with secret law. And the general said, very accommodatingly, he said he'd get back to me on that. He'd consult with his lawyers. And I appreciate that. I want him to consult and get it right. But here's what we know. We know what the plain language of the law is. If you apply for the production of tangible things, that's, as you all know, law you're taught for getting a business record, you have to do the following, and I quote from the Act. You have to provide a statement of facts showing that there are reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation. Now, that's a lot of standards thrown in there. Reasonable grounds, tangible things, relevancy, authorized investigation. So what authorized investigation is out there that allows the vast vacuuming of all of your information on your phone calls? Well, that's a fair question, and we don't know the answer. Let's focus on this keyword, relevant. Now, if it's in the law, it has meaning. Now, it implies that you take the different business records and you say, these are relevant, these are not, and you set some standard for how far removed. Is it 1 level removed? Is it 2? By the time you get to 6 points of separation, as they say, you've touched every person in the world, or in this case, every cell phone record in the world, every phone record in the world. And so the secret court has to set this standard. Now, how does the secret court do this? Well, there's a proposal made for interpretation. My understanding is it comes from the executive branch, and a judge on the secret court decides whether or not that's acceptable. But there's no advocate there to say, wait, relevancy means X, Y, and Z, and it doesn't exist. And what did we end up with? We don't know what the finding of the court was because those have not been declassified. So we don't really know what the law is, but we do know what the action or results are. And that is all phones, all the time, all across America. No sorting on the basis of relevancy, no test in the language of law. And it would be great if we could declassify the secret interpretations of the FISA court so we could actually have a conversation about what we want the law to mean. That's why I filed an amendment last December to the FISA bill calling for the AG to declassify interpretations of the law embedded in the FISA court opinions. It's why when I raised this issue, Senator Feinstein on the floor said that she supported the concept I was putting forward. She couldn't support the amendment because we had to have a bill that matched the House bill, but that she would participate, and indeed she led a letter that I joined and Mark Udall and Ron Wyden joined in asking the court itself, the FISA court, to declassify findings of laws in its opinion. We did get a reply. The answer was no, thank you. So it'd be too confusing. Well, maybe it's confusing to have law that we don't know what it means. And so that's why I refiled the December amendment as a bill this week, Senate Bill 1130. And I want to say we already have 12 co-sponsors for that bill. And I asked General Alexander of the NSA yesterday, I said, this concept of now taking these secret FISA interpretations and declassifying them so that we will actually know what the words of the law mean, Section 215, would you support that? Is that reasonable? And he answered, and he said, with a caveat, he said, I'm inclined to think that that's the right thing to do. I'm not quoting word for word, but approximately. He said, I've got to check with my lawyers, but I think that the principle makes sense, and I appreciate that. And indeed, in the last couple days, because I just filed this, I believe, Tuesday morning, the New York Times editorial board, the Bloomberg editorial board, John Healy of the LA Times, E.J. Dionne of the Washington Post, the American Association of Law Libraries, the Constitution Project, ACLU, Project on Government Oversight, Credo, OpenGovernment.org, have all endorsed making secret law public and passing that bill. I don't know if you all endorse. I see no. Okay. Otherwise, well, if you did endorse, would you support that? We've got to fix the broken Senate. I came to the U.S. Senate as a 19-year-old, interning for Senator Hatfield from Oregon. I had a terrific summer. I was assigned to work on the Tax Reform Act of 1976. And not only was I immersed in studying all the amendments that might be proposed that were being circulated and the opinions of folks back home in Oregon and opening the letters and drafting responses, but it came up on the floor of the Senate that summer. What a gift to a young man to now have to go to the floor of the Senate, actually the staff gallery, and watch the debate, take notes, and then, of course, we didn't have television on the floor of the Senate. We didn't have email. And so, therefore, what happened is senators saw the bells and they rushed to vote. They didn't know what it was. They would meet their staff members. They came out of the elevators and before they went on the floor, and you would give them the whole account. One time, Senator Hatfield said, I'm late. Should I vote up or down? And I was just out to explain that there were 3 levels of motion involved here, and one reversed the other, and this was the subtlety of it. And he's just like, no, up or down, yes or no. And I was like, yes. And he ran onto the floor, and I ran up to the staff gallery, and I thought, oh no, did I just ruin America and give the senator bad advice? I did come to realize later that the senator undoubtedly checked in with his colleagues, so all was fine, but he did vote yes. So that Senate involved amendments coming up one after the other. There was no negotiation over amendments. It was whoever got the attention of the presiding chair. And the chair probably mixed it up because there would be 10 people yelling at once, so you'd get people front and back and left and right, one side of the aisle, the other side of the aisle, and you'd just go through amendments basically until everybody was exhausted, and then you would ask for the final permission to have a vote, and you'd get it, and you'd vote, and it was a simple majority vote. Simple majority vote. What do you know? Well, this is a little different than today. I think about the fact that when Lyndon B. Johnson was presiding officer, majority leader of the Senate, in 6 years, when he asked, okay, everybody's spoken, let's have a final vote, how many times do you think he had to file a petition rather than just get consent to have a final simple majority vote? I heard 0. I heard 1. It's 1. 1 time in 6 years. Harry Reid, his first 6 years, had to file 391 petitions to try to get to a final vote. Now, these petitions are designed for rare use, and they take up an entire week. If you think about it this way, there's a debate on a Monday that's followed on from the previous week, and everybody's had everything to say, nobody else has anything left, the amendments have been proposed, and there's a request to have the final vote, unanimous consent, and somebody objects. 1 senator objects. Now, on Tuesday, you have to get 16 senators and file your petition. But then you can't vote on that petition until Thursday. On Thursday, you have to get 60 votes, and if you get those 60 votes, you have to have an additional 30 hours of debate before you can actually have a simple majority vote. So one 1-second objection on Monday produces a week-long delay. Now, last I checked, I don't think there were 391 weeks in a 6-year period. And you can start to see the paralysis that has developed. In the last 2 years, 24 appropriation bills, we heard exactly 1 on the floor of the Senate. Now, last year we had, coming out of committee, we had a bipartisan bill replacing No Child Left Behind, had strong momentum. It never got considered on the floor of the Senate because the floor of the Senate is too tied up. Now, this feeds cynicism about government not being able to solve problems. It creates the reality of government not being able to solve problems. So it's not misguided cynicism, it's realistic. That means our young folks are looking and saying, why can't we take on living wage jobs and expand them? Why can't we take on global warming in a serious way? Why can't we change other aspects of what we do in healthcare to make it work better? And so on and so forth. And they see this paralyzed body and feel a sense of hopelessness. And that's not okay. There was a time when the U.S. Senate was considered the best deliberative body in the world. and we must restore that reputation. In 2011, Tom Udall and I proceeded to try to get the Senate to move. Tom really emphasized and pursued the fact that we should have a process in January every 2 years. I was working to try to put together pieces of what that might look like. We were working together, Tom and I were. And we had 40 plus votes for a package of reforms. I think we had 46 for the talking filibuster. But we didn't change anything. And we didn't have a movement, inside the caucus or outside. 2013, January comes along, and now there's a whole bunch of senators who believe that we have a responsibility to make the Senate work again. And there's a whole bunch of organizations outside that are fighting to make the Senate work again. And I hope in all your conversations with your senators from whatever state you're in, every state you're in, you will help persuade them that it's their responsibility to be part of a legislative process as envisioned under the Constitution to address these big issues facing America. But in January of this year, we didn't get the significant changes we'd hoped for. We got basically modest changes, worked out with a bipartisan group of 8, modest changes, plus a promise of comity. Now that's I-T-Y. Well, the comity didn't materialize. Within days, John McCain was filibustering, the first ever in our history filibuster of a defense secretary who just happened to be a former Republican colleague. And then we had a group of 41 senators who wrote a letter and said, no matter who's nominated for the Consumer Financial Protection Bureau, we will oppose that nominee, no matter how qualified that person is. And then there was the budget that we passed, and we're trying to send it to a conference committee. And the Republicans are filibustering, starting the conference committee with the House, as if there's some risk there. But the levels of absurdity are high. We tried to get Gina McCarthy out of committee, and Frank Lautenberg was very sick, so I couldn't be there. And so our Republican colleagues decided to walk out on the committee so there wouldn't be the necessary quorum to be able to bring out her nomination. So he came in the following week, very ill, and then our colleagues across the aisle showed up because the walkout no longer mattered, and we got her out of committee. But we need to get her. She's been, let me stress, I want to stress the absurdity of these obstructions. She has been the environmental advisor to 2 Republican governors. And we can't get her to a vote on the floor. Or Tom Perez, Secretary of Labor nominee, incredibly qualified. And Elizabeth mentioned the National Labor Relations Board that will become completely dysfunctional if we can't get the 5 nominees confirmed. Or the D.C. Circuit Court, Caitlin Halligan, extremely qualified and rejected. And really that was a complete blow-up of the 2005 deal that was struck in which the Republicans said, they were in charge, they said, if you keep filibustering, we're going to change the rules. And so the Democrats said, no, don't change the rules, that'd be terrible, so we'll quit filibustering. Well, wouldn't it have been better to change the rule? The delays, I'm sure you've heard these many statistics. You can cut it any one of a number of ways. It was 29 days for an unopposed nominee under the Bush administration. It's basically 4 times that for Obama, 124 days. Or look at it as 14 filibusters of nominations a year for Obama, 1 per year for Reagan. You can go on and on. It is a conscious strategy to paralyze the president and pack the court, and that is unacceptable, and we have to change it. I think about how would Franklin Roosevelt have helped lead us out of the Great Depression if he couldn't have gotten people into position and he couldn't have gotten legislation voted on the floor. So what to do? Well, on the legislative side, we need to end the filibuster on the motion to proceed, straighter up and down vote, give people an hour to debate it. We need to end it on getting to conference committee. Both houses have approved a version of the same bill. Why blockade the start of negotiation to try to get a common product? We need to change the 60 votes that are required to end debate to 41 to continue debate, so those 3 to 5 senators who might be absent count for closing debate rather than for paralyzing the Senate. And if 41 senators say they want more debate, then they have to debate. They have to be there, one at least, on the floor of the Senate. Having one on the floor of the Senate speaking at all times is a pretty modest request. It's one of 41. And what it does is it tells the American people when they tune into C-SPAN that there's a filibuster, because right now they're invisible. We have the silent filibuster because the burden is on the majority to get 60. No one has to talk. And when those 41 decide that they have said enough, or the American people weigh in and say, you are a hero, keep going, or you are a bum, sit down, the American people will help the Senate close debate and get to a final majority vote. James Madison and Alexander Hamilton had a lot to say about this. James Madison said on the supermajority, he said, it would be no longer the majority that would rule. The power would be transferred to the minority. Were the defensive privilege limited to particular cases, an interested minority might take advantage of it to screen themselves from equitable sacrifices, or in particular emergencies to extort unreasonable indulgences. Or what did Alexander Hamilton say? He said in Federalist Paper 22, and he was speaking from his painful experiences as a New York delegate to the Articles of Confederation Congress. He said, a supermajority rule results in, and I quote, tedious delays, continual negotiation, intrigue, and contemptible compromises of the public good. Well, not exactly high praise for a legislative or nomination supermajority from our founders. And indeed, Hamilton, he also went on to talk about the challenge in nomination power. He believed the nomination power should be kept with the president and not the legislative branch to avoid the party likings and dislikes, partialities and antipathies, attachments, animosities, which are felt by those who compose the assembly. Doesn't this sound familiar? And he went on to say the Senate should vet nominees based on the intrinsic merit of the candidate and the advancement of the public service. And he stated that he expected nominees to be rejected only when there were, and I quote, special and strong reasons for the refusal. It was very conscientious that the founders put into the Constitution a supermajority for treaties, and they didn't put in a supermajority for nominations or for passage of legislation. So we have a lot of work to do to put our democracy back on track. Be it Citizens United, 501c4s, secret law, fixing the broken Senate, and I should add, doing a little repair work on the House side too. It's a lot of work worth doing. And through this organization and through other organizations you belong to and through your personal conversations with legislators, you can make a big difference. Robert Kennedy came through Oregon just before I went to California and was assassinated. I was in 6th grade. I heard that he was speaking at the high school. I remember going home. My dad was a mechanic. And my dad came home from work. He was very tired. I said, let's go down to the high school and see this man running for the U.S. presidency. He said, oh, son, I'm too tired, but you can go ahead and go. I have always regretted that I did not go down to the high school and hear him. But this is what Robert Kennedy said. Each time a man stands up for an ideal, or acts to improve the lot of others, or strikes out against injustice, he sends forth a tiny ripple of hope, and crossing each other from a million different centers of energy, and daring those ripples, build a current which can sweep down the mightiest walls. There are some important walls to sweep down. Let's do it. Thank you.